So welcome everyone to this Constitutional Law Center of Constitutional Conversation is what we call this series. We are doing two segments, but a couple weeks ago we did a segment on what would be the implications for constitutional law if President Trump is reelected, and tonight we are doing the same question, only for if former Vice President Joseph Biden is elected. And in both cases, what we've done is to invite a distinguished law professor with some associations with the candidates to speak, one person to speak who's more or less supportive of the candidate, and then another to be the counterpoint or devil's advocate or the opponent of the candidate. And tonight I am very pleased to introduce our two speakers, beginning with Professor Jillian Mezer, who's the Harlan Fiske Stone Professor of Constitutional Law at Columbia Law School. Love that title. My, that's a distinguished sounding title. Jillian is kind of a lifelong Columbia person. She grew up in the Columbia faculty housing, went to Columbia Law School, was a lawyer for a while for the Brennan Center. She clerked for Pat Wald and then for the late Justice Ruth Bader Ginsburg, for whom we're going to have a bit of a commemoration in just a moment. And on the other side of the proposition is Jonathan Mitchell, who is a graduate of the University of Chicago Law School. He has taught at a variety of law schools, including, I think, for the longest period at George Mason, but also at Chicago, Texas, and as a visitor at Stanford Law School. He is best known for having served for 5 years as the Solicitor General of the state of Texas, which is one of the leading state Solicitor General's offices. While he was there, he represented the state, kind of an ideologically mixed bunch of cases. He defended affirmative action at the University of Texas and also helped put together the original litigation with regard to the immigration DAPA program. He is now awaiting, he's been nominated and is awaiting confirmation to be the head of the administrative conference, which is the leading national organization about administrative law. So our idea of these two sessions is that there's been a great deal more heat than light, a lot more rhetoric than substance in much of the debate, and this gives us a chance really to have serious people talk seriously about these serious questions. And so we hope you'll find it informative. Now, before we begin, though, the death of Justice Ginsburg has touched many of us. Jillian, having clerked for the justice, more than most, and we thought, given the topic tonight and her recent demise, that it would be appropriate to begin before our session, to begin with a moment of silence, just to remember her and to honor her memory. So, if you would please join me just for a brief moment of that. Thank you. And now, Jillian.
Thank you, Michael. I'm actually really delighted these days to have any chance to pull my mind away from our current reality. So reflecting on what a Biden administration and would mean for constitutional law is actually really a treat, and I appreciate the chance. Let me give one caveat at the outset, and that is that what a Biden election would mean for constitutional law is going to depend a fair bit on other elections, in particular, I think on whether or not the Democrats gain control of the Senate and Congress. I don't think it's going to depend on that entirely. And in fact, I think some of the most important constitutional impact that Biden can have is going to be on how he wields presidential power, the rules and norms he imposes on the executive branch. But I do think what happens outside the executive branch in the election is going to matter a lot, and I'll have some comments on that. I'm going to begin, though, focusing on presidential power and the executive branch, and then I'll move on to considering constitutional law in Congress and in the court. Okay, so one thing that constitutional scholars do when they're thinking about constitutional law is they emphasize that much of constitutional law consists not of provisions in the Constitution or judicial decisions interpreting it, but of what is often called constitutional conventions. These are long established and unwritten norms and practices that control how the government operates. They're not really law in one sense at all, and that they're not legally binding, but they are understood as practically binding. Or rather, they were understood as practically binding. One of the signal features of the Trump presidency has been his willingness to break many of these constitutional conventions. And let me just give a couple of examples. So from the outset, he has violated what were previously pretty strong norms of presidents disclosing their tax returns and their finances, avoiding appearance of a conflict of interests. There are certainly laws in play here. There's the Emoluments Clause as well. But in the past, really, the primary prohibitions have been conventions. This is what presidents did. Similarly, prohibitions on presidents directly using their office for political gain, as we saw recently during the Republican convention. There's been pretty strong prohibitions against that. And similarly about presidents interfering in law enforcement or using the pardon power for personal interests, not undermining key accountability structures like inspector generals, not attacking the legitimacy of elections. All of these are at odds with what have been pretty long-standing conventions about how presidents operate. And what's true about all of them is that these are things that presidents, technically had the power to do. And some might even claim trying to incorporate these prohibitions in statute might unconstitutionally intrude on the president's prerogatives and constitutional powers, but they are all instances of behavior at the same time that were generally regarded as abuse of authority and at odds with the rule of law. And it hasn't been an urgent problem because most presidents, again, really adhered to them. The fact that President Trump hasn't means that when Biden comes into office, he is going to face, I think, a real pressing imperative to recreate and reinforce these norms and conventions on presidential behavior. And I think also in the face of the number of Trump's violations of these conventions, simply tacitly reinforcing them by adhering to them is probably not going to be enough. I think there's going to be a push for more of an express articulation in executive orders or presidential statements of these norms. So I actually think that one of the most important constitutional contributions of a Biden presidency will be the express articulation and elaboration of norms and conventions that govern the presidency and imposing limits on certain exercises of presidential authority from within the executive branch itself. We've certainly had a lot of that internal law before. I mean, if you just think about OLC opinions, they're a prime example of internal executive law, executive branch expositions of restrictions at times on the presidency and of constitutional law more generally. And you do also see presidents often issuing executive orders that do this. Obama, for example, at the start of his administration had executive orders on ethics and torture, which could be seen in this vein. But what I think what's different today is simply the broad scope of issues that are going to need attention and the number of them that are actually intra-executive branch, right? There certainly are important norms and conventions about the relationship of executive branch officials to the outside world. I think how federal law enforcement personnel are deployed and use force. That's one example where I think that's going to be another area where you'll see some executive branch exposition of restrictions. But I think it's really interesting that a surprising number of these pressing issues do involve intra-executive branch relationships. So for example, the relationship between the White House and DOJ is something where I think you're going to see some articulation of norms, and I consider these constitutional norms and practices. Similarly about, norms about when do you remove agency watchdogs, so forth. So that's one thing I think we really can look for in a Biden administration that will be a contribution to constitutional law. Some of these will, insofar as they involve how agencies operate, may be put forward in the form of regulations or agency issuances, and in that sense might seem to have a little bit more binding power. They at least would bind until another administration changed them, or the Biden administration changed them through the proper practices of rulemaking, and conceivably could trigger some judicial review. But primarily these are self-imposed restrictions from the executive branch itself. That leads me to Congress, because if you really want to embed these restrictions on the presidency and give these norms and conventions additional solidity, one way to do that is through legislation. And a leading precedent here is the period after Watergate, where we similarly had a nation confronting some real abuses of executive authority. And there, President Nixon's abuse of power triggered a large array of congressional enactments that imposed limits on the presidency. So you had the War Powers Act, you had the Empowerment Control Act, you had campaign finance reform, privacy protections, limits on intelligence collection, civil service reform. You just had a whole array of regulations of the executive branch and of the behavior of the presidency and these president in some key areas. And I think we may very well see that again now. There are numerous proposals for similar congressional undertakings in the period after Trump. That is in part legislation codifying many of these norms, for example, about disclosure of tax returns or financial conflicts of interest, but also legislation proposals that go further, and particularly that provide protection for certain forms of constitutional rights, especially the right to vote, which have been seen as under attack. And I would expect many of these proposals would be strongly backed by a Biden administration. I think many of them actually might garner bipartisan support. I think that's been difficult to do with Trump in office, but I would not be surprised if there are Republicans after Trump is no longer in office and we are under a Biden administration that might be quite willing to think about codifying some of these norms in statutes. Not just because it's a Democratic president, but I think actually because these are norms that people do, there is bipartisan support for. And so this gets me to the point that the caveat that I made at the outset, which is to what extent will the constitutional law of a Biden administration depend not just on the presidential election, but also on whether the Democrats win control of Congress as well. Again, for many of these measures, that won't be necessary, but for some, in particular, protecting the right to vote, restrictions on campaign finance, those are going to be highly contested, and I think they will depend on whether they get enacted, will depend on whether or not the Democrats are able to control Congress. And if you think in particular some of these rights, for example, political gerrymandering, if that's something that legislation is enacted to adopt, the presence of legislation to deal with those will be particularly helpful or important because the court has actually said, the courts has pulled that out from the courts recently by considering political gerrymandering to be a political question. So the role of legislation here in sort of creating constitutional law may be quite significant. It's not an area where the court has been willing to step in. I also think that if the Democrats win control of Congress and have both the Congress and the White House, I expect we're going to see enactment of legislation to address broader urgent problems. So climate change, immigration, healthcare. And I think I would call these constitutional, but maybe in a small c constitutional way. These are measures like Social Security, like Medicare, major legislation that reconstitutes the polity, creates really important new structures of governance, redefines in some ways what we understand citizenship as being, but they rest on legislation, not on the big C Constitution. At the same time, these measures are likely to involve the big C Constitution as well, because they will raise questions about national power under the Constitution and its scope. And I would fully expect legislation, for example, addressing climate change or healthcare or any of the kind of major legislation we might see in this scenario to face constitutional challenges, either as exceeding the scope of federal power or as representing perhaps excessive delegation to the executive branch. I actually think many of those challenges are likely to be forthcoming even if the Democrats don't win control of Congress. And the reason for that is, in that case, there will then be, I think, a fair bit of pressure on the Biden administration to use administrative power under existing statutes, as there was on President Obama, to deal with some of these pressing problems. And well, it remains to be seen how the Biden administration will respond, or whether they'll take a more incremental approach in that context or a more aggressive use of administrative power. I still think you're going to see lots of legal challenges to that. And part of that is because of where constitutional law has gone generally, and in particular the extent to which challenges to national administration have become really a real bulwark of conservative legal activism. And I think you'll see many red state governors, as we saw under Obama. We've had the blue state governors doing it under Trump, bringing litigation challenging Biden administrative action on these kind of constitutional grounds. So no matter what, whether the Democrats win and we're seeing new legislation, or whether they don't have control of Congress but do have the White House, and so we're seeing more administrative action, I think it's quite likely that we will see some big ticket structural separation of powers, but also scope of federal power litigation happening. And so that then brings me to the courts. How the courts respond to those challenges, how the political branches respond to potential judicial invalidation of sort of major progressive legislation, if that's what occurs. That's going to be a big part of the Biden administration's impact on constitutional law. I think reasons exist to think that these types of constitutional challenges would find a receptive audience at the Supreme Court and the lower federal courts. It obviously will turn on the specifics of any particular legislative or administrative measure that's being challenged. That's going to matter a great deal. But one of the main achievements of the Trump administration has been to stock the federal courts with a large number of conservative jurists, jurists who, among other things, have been vetted by the FedSoc and other organizations that have really put a prime emphasis on skepticism about the administrative state and this kind of national power. And that's been one of the main criteria for selection of judges. And so it's not surprising that we see the courts more receptive to those challenges. And you see that on the members of the Roberts Court in particular. You see it, both Chief Justice Roberts has voiced that, Justice Clarence Thomas has voiced that, Justice Neil Gorsuch has voiced that. And so there's been support, substantial rhetoric on the court espousing these kinds of arguments. There are, I think, likely 5 votes to reinvigorate the non-delegation doctrine, for example, in some form. What's held that move back at the court, and one reason why its rhetoric hasn't yet matched its action in specific cases, has been Roberts's concern, I think, about the institutional legitimacy of the court. If Judge Amy Coney Barrett is appointed to the court before a Biden administration takes office, however, Roberts is no longer going to be the swing vote on the court. And at that point, I think there really will be a court that would be pretty solidly receptive to many of these challenges. And so that's going to raise some real questions about Biden's legacy for constitutional law, particularly focusing on how he and his administration respond if the court strikes down key progressive initiatives. And what his administration and those moves might mean then for the relationship of the political branches to the court. Would his administration, for example, get legislation passed changing the court's composition? Would it try and do moves in terms of limiting the court's jurisdiction? All of those are proposals that are on the table. And whether or not those will get enacted is actually being raised even now, just in response to the nomination and seemingly likely confirmation of Judge Coney Barrett. But I actually think it may very well be that those matters don't happen at the outset. They're left pending until specific challenges come either to these kinds of measures that may get passed by Congress under a Biden administration that are sort of bigger ticket progressive legislation, or over time what happens with challenges to abortion restrictions and so forth. And so I think these are issues that may very well be pending for a while under a Biden administration, and what the response of the court will be to these kinds of initiatives under a Biden administration, and what the Biden administration's response will be to the court's response, are really going to be, I think, the key elements to Biden's impact on constitutional law. I think it's actually hard to predict at this point what's going to happen. There are so many variables in calculating that out. Among other things, even if the Democrats control Congress, there are many Democrats, and Biden may very well be one of them, who will resist efforts to impose some of these measures on the courts. It's not clear that the Democrats would have a clear path to that. More importantly, there are going to be pressing issues like the pandemic, like an economy that is suffering from all the effects of the pandemic, that are guaranteed to take up the administration's attention as soon as it comes into office. So, playing out those political issues of trading off between the court and that, again, that just remains to be seen. And it's not clear also how the court will respond. We may very well have a repeat of the 1930s, where in the face of a court that was striking down key parts of the early New Deal, and you had FDR's threat to pack the court, the court ended up sustaining many measures. Whether that was in response or a trend that was happening all along is something that legal scholars debate. But the reality is that in just a few years, those measures from FDR and the New Deal were being upheld, and pretty quickly FDR had control of the court. So it's quite possible we may see a similar kind of dynamic. A lot of that will turn, I think, on what happens in the election writ large, how much support there is for Democrats, and again, if whether or not they win control of both of those institutions of government. So I do think that the issue of the relationship of the political branches of the court will be a key issue of the Biden administration's legacy, but I just don't know yet exactly what form it will take. Thanks.
Thank you, Jillian. Jonathan?
Hey, thanks, Michael. So I'm pessimistic about the future of constitutional law, regardless of who wins the election. And my claim today is that I think all of us have reasons to be pessimistic as well, regardless of where we may stand on the political or jurisprudential spectrum. There are two trends in constitutional law that I find troubling, and I expect each of these trends to continue, regardless of whether Joe Biden or Donald Trump wins the election. The first is that the Supreme Court's constitutional pronouncements are becoming more and more detached from what the Constitution actually says, and the court is increasingly using judicial precedent rather than constitutional text to justify the expansion of constitutional law into new domains. This is something that the conservative and liberal wings of the Supreme Court are doing in equal measure. They're doing it on different issues, to be sure, but they're both doing it. On the right, you have cases like Shelby County against Holder, where Chief Justice Roberts claims that the Constitution requires, quote, equal sovereignty of the states, unquote. You can't find that anywhere in constitutional text. So to provide authority for this idea, the Chief Justice cites his own prior opinion in Northwest Austin, which in turn cites not constitutional text, but other judicial precedents rather than the Constitution itself. On the left, you have decisions like Obergefell against Hodges, where the Supreme Court tells us that it can recognize fundamental rights by applying what it calls reasoned judgment rather than by looking to what the Constitution says. Many more examples that we can give on both sides of the aisle. And just to be clear, I'm not saying these cases were wrongly decided. I'm just pointing out that the court's rationale for these decisions was not grounded in constitutional text, and the court tried to create a legal veneer for its ruling by relying on its own precedent rather than the Constitution itself. Second concern that I have is that the constitutional doctrines generated and developed by the Supreme Court are becoming more loose and indeterminate, which allows the ultimate applications of these doctrines by the Supreme Court and by lower court judges to be influenced, if not entirely controlled, by the ideological priors of the judge. There are many examples that we can give. The most famous is probably the so-called undue burden test that the court uses to judge abortion regulations. That is a non-falsifiable standard. Nobody knows the point at which a burden crosses the line from due to undue, and the way the judges apply that test correlates unsurprisingly with the political party of the president that appointed them. But there are other examples. The court's standing and justiciability doctrines are also notoriously slippery. There's really no non-arbitrary way to deal with questions surrounding potential future harms and when that confers standing to sue. The arbitrary and capricious test and administrative laws becoming more and more conducive to results-oriented judging with each term of the Supreme Court. And there's been talk on the Supreme Court of potentially reviving the non-delegation doctrine. Whatever you think of the doctrine and whatever you think of agency power, I'm certainly no cheerleader for administrative agencies, but I've never seen a test put forth for the non-delegation doctrine that is capable of principled application that wouldn't lead to what we would expect to see in the undue burden context, where we have largely the results being driven by ideological and political backgrounds of judges rather than by actually applying constitutional text or some legal standard that's capable of producing consistent results. So the Roberts Court has been aggravating rather than mitigating these trends. Chief Justice Roberts has been moving the law to the right, but he's doing it not by removing the court from areas where it never should have been involved in the first place, not by overruling the non-textual pronouncements of his predecessors. Instead, he is expanding the court's role into new domains where the textual justification for what he's doing is questionable at best, and the evidence of original meaning is either conflicting or in some cases stacked against him. Take a look at the Consumer Financial Protection Bureau case from last term. If you haven't had a chance to read it yet, Justice Kagan's dissent is absolutely devastating. Scholarly and thorough analysis of constitutional text and the relevant history, and then you read the Chief's majority opinion. It's facile. You compare the two opinions. It's almost as though the Chief doesn't care whether the constitutional text or original meaning actually supports his conclusion. That's certainly the impression I got from reading his opinion alongside Justice Kagan's dissent. Then you compare that to his behavior in the Louisiana abortion case, where he decides to keep the Supreme Court in the abortion umpiring business in the name of stare decisis. And add these things together, it appears that the Chief Justice's long game is to leave in place the textually dubious constitutional pronouncements of his predecessors on account of stare decisis, while simultaneously imposing conservative policy goals through constitutional pronouncements that are only weakly tied to what the Constitution actually says, and that deploy precedent-based reasoning rather than textual analysis. So what will happen if we combine a Supreme Court that is behaving in this fashion with the Joe Biden presidency? I see two possibilities. One is that the Supreme Court, despite its conservative majority, will make a conscious decision to hand liberals and progressives occasional but significant victories in an effort to blunt progressive opposition to the textually dubious conservative rulings that the court will continue to issue in the field of constitutional law. That may explain the Chief Justice's behavior during the Supreme Court's last term on the Louisiana abortion case. Because as long as liberals and progressives cling to Roe against Wade, they have no standing to complain when conservative justices advance constitutional rights or doctrines with no textual basis and no historical pedigree. Sauce for the goose is sauce for the gander. And that may provide some motivation for a solidly conservative court to nonetheless keep decisions like Roe against Wade or Obergefell on the books, because it lets them show that, hey, everybody does this, right? Don't accuse us of acting lawlessly when your people do the exact same thing. Another possibility is that Judge Barrett gets confirmed and Justice Kavanaugh isn't willing to act in the way that Chief Justice Roberts did last term, and then the Supreme Court has nothing left to offer progressives, and we're left with a court that is not only conservative, not only imposing conservative policy goals from the bench, with weak to non-existent textual support in the Constitution, but they're also whittling away, if not outright overruling, past precedents on abortion rights and criminal rights and matters of that sort. If that were to happen during a Biden administration, I would expect to see progressive theories of constitutional law perhaps start moving toward where they were in the early 20th century, where progressives were skeptical of judicial power. They were embracing Thayerian deference to the political branches rather than a living constitution mindset that most progressives embrace today. I don't think this is likely to happen because I expect that Chief Justice Roberts will still wield considerable clout given his power to assign opinions, even though he'll no longer be the median justice if Judge Barrett gets confirmed. You know, the Chief Justice can still control the court's rationale through his opinion assignment power, and his colleagues will have strong incentives to accommodate his desires because he can punish them by assigning them tax and Indian cases. So I would expect the Supreme Court to continue behaving in a manner similar to the way it did last term. And this will continue to be John Roberts' court, for better or for worse. But with all that said, I want to close my remarks by just calling into question the progressive faith in the Supreme Court, which is still widely held throughout our legal and political cultures, and which is somewhat understandable, but in my view, ultimately misguided. Many progressives, certainly over the last 50 years, have embraced judge-empowering interpretive methodologies and the idea of a living constitution. And they've done so for perfectly understandable reasons. It can't be denied that the Supreme Court has improved our society through constitutional pronouncements that have been controversial and textually dubious, but normatively desirable. And it also can't be denied that progressives have obtained policy goals through the courts that they could never have obtained through political persuasion in each of the 50 states. And it's also reasonable to believe that judges are more likely to share progressive values on social issues because only lawyers can be judges, and the median lawyer is well to the left of the median voter, especially on social issues. But with all of that said, there are also reasons to think that empowering judges will hurt the progressive agenda on net. And consider some of the following. Number one, there's just no way to ensure the judiciary is composed of judges who share your values. And just because the Supreme Court has had a consistent liberal majority on social issues for the last 50 years does not mean that will continue forever. Second, the conservatives have figured out that the legal profession leans left, and Professor Metzger alluded to this in her talk, because since they've been burned by appointees like David Souter, they've created institutions and mechanisms like the Federalist Society, and they've instituted extreme vetting processes to ensure that Republican politicians appoint judges who share their values. The third thing to think about is judges are selected by the president and the Senate. The Electoral College and the Senate are both biased in favor of the small states, which tend to lean conservative. The last two Republican presidents lost the nationwide popular vote in their first election, but still won the Electoral College. And these are the institutions that appoint the judges, and both of them, given the way that they're selected, are going to tilt in direction of the small states, which gives conservatives an advantage. And then if we look at the course of US history, the Supreme Court has done far more to thwart progressive legislation and policy goals than it has to advance them. The Warren Court was very much the exception. It wasn't the rule. The Supreme Court, if we go back to the beginning of the country, it was a bastion of pro-slavery ideology before the Civil War, not just with Dred Scott, but decisions like Prigg against Pennsylvania, written by Joseph Story. The Supreme Court was hostile to civil rights legislation in the wake and the aftermath of the Civil War. We all know about the Lochner era. The Rehnquist and the Roberts courts, even though they remained liberal on social issues like abortion, they issued all sorts of rulings that thwart the enforcement of progressive legislations. And then finally, we have to at least consider the possibility, consider the hypothesis that the Supreme Court's activism in the area of abortion and same-sex marriage may be contributing to the election of Republican presidents. You look at the way Donald Trump won the election by razor-thin margins in Pennsylvania, Michigan, Wisconsin, the way George W. Bush won his election, very close margins in Florida in 2000, Ohio in 2004. Obviously, you can't prove whether this was the but-for cause or whether this actually made the difference. But when Donald Trump gets 81% of the white evangelical vote, more than Romney got in 2012, and the issues of the Supreme Court, the vacancy in 2016 was such a salient campaign issue, one has to think whether this is actually contributing to the election of presidents who are then setting back the progressive cause on so many other areas like climate change and income inequality and access to healthcare and other matters of that sort. So it's just too simplistic to assume that because the living Constitution has produced some high-profile victories for the progressive cause, that the court's behavior overall is a net positive for the progressive agenda. There are just many different factors at play here, and they all cut in different directions. So I'm hopeful that a Biden administration may lead more progressives to question their faith in the court. If we have a solidly conservative Supreme Court going head to head with a Democratic administration that's attempting to get its agenda passed, I'm not ultimately optimistic that will happen, because no one wants to give up their hard-earned victories that they've achieved either on the right or the left over the last 50 years from the Supreme Court. But nonetheless, I think it's something everyone should consider, regardless of where you stand on the political spectrum.
Great, thank you very much. So we have a lot of questions in the queue. A couple of people seem to be happy about the possibility that the Supreme Court may reinvigorate the non-delegation doctrine. It seemed like both of you were skeptical, so that's interesting. Maybe that's a point of agreement. So first question is, are you skeptical, and do you have any sense about what a reinvigoration of the non-delegation doctrine may actually look like, given that that's maybe one of the biggest objections to it, is it's hard to figure out how it could be reinvigorated in a way that's principled and sensible?
Yeah, I mean, actually, I think there's more than that on questions where we agree. I mean, I disagree in terms of the concerns that you articulated at the outset in terms of relying on precedent. But the main points that Jonathan made about progressives not being well served by the Supreme Court, I very much agree with. In fact, I would say I think most progressives agree with. The one part where I might disagree is that I think you may have had prior generations who were more willing to put their faith in the Supreme Court, but most progressives I know have not been willing to do that for a while, and reflecting the fact that we've had a very conservative Supreme Court for a while. It's important, I think, to separate out some specific decisions involving individual rights, Obergefell, for example, where there has been success at the Supreme Court, but those have come because of lobbying and political movement campaigns in the states, and that have led to legislative changes. They're not leading with the court in those cases, and I think progressives are very well aware of exactly the points that you made, that the Supreme Court has not particularly well served progressives over time. The traditional progressive view at the outset of the 20th century to keep the courts out would mean we would have a number of measures that I think are particularly concerned to progressives still functioning. I would maybe qualify just a little bit there before I get to non-delegation and say I think we might, one difference may lie in terms of the right to vote and issues surrounding the right to vote, where legislative efforts have fallen at the Supreme Court, and it will be interesting to see how much new legislation to protect that succeeds. But on non-delegation, there I think we're actually pretty close. I mean, there's the problem of how do you implement, which I think is absolutely a critical issue with any effort to revive the non-delegation doctrine. Justice Gorsuch, in his dissent in recent Gundy case, when he tried to do that, made a distinction between filling up the details and making policy judgments. That I think is very much going to be a distinction in the eye of the judge deciding a case, and I think that's a significant problem. I also just think in general, part of the problem with reviving a non-delegation doctrine, leaving aside it also does not have the originalist basis that is often claimed for it, is that it doesn't fit our current governance realities. I don't think that we want to go back to where we don't have a lot of key programs that people rely on today and that are basic to the fabric of our government and our society. And so trying to revive a non-delegation doctrine in a very restrictive form is just going to run flat into political realities that I think will overcome it.
Yeah, and I think what I would add to that is there are better ways, I think, for those who want to control the power of agencies than trying to seek revival of the non-delegation doctrine. There are other tools, I think, at the disposal that will lead to more principled judicial decision-making. One possibility is to look to the appointments clause, which that's not going to be able to counteract every broad delegation, because often the delegations are made to people appointed in conformity with Article 2. But you look at some decisions from the Supreme Court, like Little Sisters of the Poor from last term, there's language in Little Sisters that almost seem to be begging for somebody somewhere to bring a non-delegation challenge to the underlying statute. that dealt with preventive care and the Affordable Care Act. So it really looks to me, not just with Justice Gorsuch's dissent in Gundy, which the Chief Justice joined, but this majority opinion from Justice Thomas last term in Little Sisters, signed by 5 justices, that really seems to signal that they're trying to go in this direction. But as Professor Metzger said, I haven't seen yet a theory for distinguishing a permissible from an impermissible delegation that isn't something akin to the undue burden test that we have in abortion. It has an I know it when I see it quality. I didn't see Justice Gorsuch's dissent in Gundy as providing that test. Perhaps Professor Metzger knows of something out there in the academic literature because she's a scholar of administrative law and I'm not. But I just haven't seen anyone either in the courts or the academy come up with a test that promises to be applied in a way that will lead to decision-making that could just transcend the ideological preferences of the judge. I'm really concerned about having more constitutional doctrines out there where you can ask judges who are totally conscientious, acting in very good faith, but from different ends of the political spectrum, and they're going to reach different results just because they have nothing to fall back on other than their ideological priors when they apply a test of that sort. So that's my issue, I think, with non-delegation. And then with what Professor Metzger said about progressives and faith in the Supreme Court, I certainly think that's true of progressives in the academy. But I don't think that really has quite trickled down yet to progressive politicians, Democratic Party politicians, or the general public. Maybe I'm wrong in thinking that. But when I see Professor Kramer, Professor Tushnet embracing popular constitutionalism, I just haven't seen any political officials in the Democratic Party trying to start pushing these ideas. Or it just seems that the progressive skepticism right now seems more confined to academic circles, and it just hasn't quite left that yet. I'm wondering maybe if there are more clashes between the Biden administration and a conservative court, similar to what we had in 1930, perhaps that will help move that outside the academy and into the public at large.
So there's quite a number of questions about potential structural changes to the judiciary. So there's a kind of couple in this area. One was specific to Professor Metzger. Do you think that a 9-justice Supreme Court is one of the kind of established conventions that you talked about? But then just more generally for both of you, what do you think about these proposals to add justices to the Supreme Court, to strip the jurisdiction of federal courts in certain areas? Are any of those likely, and are they good or bad ideas?
Well, I'm happy to take the first stab at that. In terms of the second part, the different proposals, again, I think it depends a little bit on what happens politically. If you have what you had in the 1930s, where the court came into line with public opinion fairly quickly, I think that there will not probably be as much popular support for major structural reform in the court. On the other hand, if major reform legislation is struck down, I think that will really tee up that issue. I myself, in my own view, have moved from being concerned about some kinds of reform proposals to thinking that we really need to have a term system or staggered appointments. Too many presidential elections, going back to something that Jonathan mentioned, too many presidential elections are being elected on the Supreme Court, and I think there are better things to elect your presidents on. And so, I think that would be something that would be good to move towards. In terms of whether 9-justice court is a convention, I think it has been. I think it's one that has now adhered for a while. Certainly is one we've had deviations from, and we've had quite overt changes of the membership of the court to deal with not letting particular President Johnson appoint somebody to the Supreme Court. So we certainly have that in our history. I think we've been at 9 for quite a long time, and that's been a pretty strong norm. On the other hand, we've had some real changes to the nomination process for the court and to the court's makeup. And I think one thing that you've seen, going back to what Jonathan said, there's been much more very careful determination to find people who will vote a particular way on certain issues in terms of nominations. One reason why the 9-justice has held is because I think we had just a court that the justices were a little bit more fluid and a little bit more responsive to changes in broad public opinion. And as a result, popular pressure to reform the court wasn't as strong. So part of what's happening now is we have this very careful and elaborate and many decade-long strategy to take control of the courts, and that may undermine the Convention of Nine. And I also think right now we have a court that has been divided into ideological blocks based on the party, very closely reflecting the party of the appointing president. And I just don't think that's a good place for the court. I think it will lead to these kinds of situations where there's pressure to change the makeup. So it may have been a convention in the past, but we have violated other conventions surrounding the court, and this may be one that in the end is changed as well. We'll have to see.
Yeah, I mean, thinking of these proposals, I'm doubtful they will get 60 votes in the Senate, and I'm also doubtful the Democrats would change the filibuster rule to push something like this through. But I think it's still interesting to talk about these ideas, and they're worth considering. In my view, the law right now is just over constitutionalized. The court is taking on too many areas. They've made too many questions into constitutional questions to be resolved by judges without any textual warrant for doing so. And without being able to create doctrines that are capable of applications that don't wind up being, as Professor Metzger was saying, a 5-4 split on ideological lines, just because their own doctrines that they've created are leading to those types of results. So how do we fix the problem? Is it by enacting jurisdiction stripping legislation, or getting Congress to enact a statute that uses the exceptions clause to take away the Supreme Court's appellate jurisdiction? Again, whether that's a good idea will depend on whether I think Congress has the better view of the Constitution than the Supreme Court. I hate to give such a squirrely answer to that. I certainly think Congress has the authority under the Constitution to control the court's jurisdiction under the exceptions clause, and to control the jurisdiction of the lower federal courts based on Article 3. And we will see if the courts uphold those. Maybe the courts would say that the effort to take away the court's jurisdiction is itself unconstitutional. I'm not sure. But I don't have any problem with the political branches trying to be more assertive in their role on constitutional interpretation. I think for too long, we've all assumed that only the Supreme Court gets to decide what the Constitution means, and they get to impose their views on the rest of us. Actually, the political branches have the ability to interpret the Constitution as well, and they have tools at their disposal to bring a recalcitrant Supreme Court into line if they choose to use them. So with respect to the number of justices, I mean, arguing before 9 justices is hard enough. I can't imagine what it would be like to argue before 13 or 11, just as an advocate. But again, I don't expect these proposals to get the 60 votes they need to get through the Senate.
So one of the people in the audience expresses some skepticism about Professor Metzger's optimism about a President Biden administration willingly limiting the executive power. Some people thought that President Obama should do this after President Bush, and there wasn't a lot of evidence that he did. And so is there anything that you can give us to give us some more hope that that's a realistic possibility? And then maybe, Jonathan, you can sort of just jump in as you see fit.
Sure. I mean, so yes, anyone would have to acknowledge that presidents have not been exactly good at limiting their own power of late. I think that the situations of a President Biden and a President Obama are quite different. I think that Biden would be coming into office against a very stark image of how much power a president can assert and the kind of unilateralism that an unchecked president can do. And I think that there will always be pressures to achieve certain kinds of policy goals. As I said, particularly if you don't have Congress, or depending on what happens, as Jonathan pointed out, with the filibuster in terms of control, ability to get measures through Congress, how much use of administrative power an administration will use remains open questions. But I think that it'll be a very strong effort and commitment, because it's just been a key part of the Democratic Party over the last 4 years to reinforce certain kinds of rule of law norms and issues of presidential abuse of power. Will it happen across the board? I mean, we're prognosticating things in the future, but I think you will see certainly some. And for example, I think you will clearly see, just from what has been said recently, statements about presidential interference with decisions that statutorily are given to expert agencies to handle on scientific grounds. I think you will see if you think about the pardon power, particularly if Biden comes into power after Trump does some pardoning after he loses the election, I think there'll be very strong pressure to adopt some norms about how you use the pardon power. And again, I think there may actually be bipartisan support for legislation in some of these areas, leaving aside the scope to which Congress can even regulate the pardon part, but say something like self-pardons by president or something really quite extreme. I think there may be bipartisan agreement on some of this. There may be bipartisan agreement on protecting inspector generals or other kinds of measures against some kinds of abuses. So I am actually, in that sense, a little bit more optimistic that we will see some of these measures precisely because of what has happened over the last 4 years.
I think if we read James Madison, he always seemed to promote the idea that institutions and institutional actors will want to increase the power of the institution that they serve. That was part of his theory of separation of powers. But I think Professor Darrell Levinson's pointed out it's more nuanced than that. Political actors respond to political incentives, and sometimes the political incentives are to engage in acts of self-abnegation and forego powers, limit the powers of your institution just because either it's the right thing to do or there's political pressure to do that. And there are many examples. It's not just presidents who can disclaim presidential powers or agree to formal limits on their powers through either OLC opinions or other types of executive orders, but Congress sometimes will not reach as far as it might be able to under its Article 1 powers just because of the political safeguards of federalism. And we see judges sometimes who invoke doctrines of justiciability and judicial restraint or deference to agencies, limiting their own powers in certain ways. So there are plenty of times where you can see actors through all three branches of our government act in ways that may limit their own power or limit the power of their institution just because there are overriding considerations and other incentives that override what the basic Madisonian framework might suggest.
So one of the panelists is wondering whether you have any thoughts about how a Roberts Court that has Judge Barrett on it would be likely to think about a new Voting Rights Act that uses, more contemporary, robust evidence than the one that they struck down in Shelby County.
So actually, that statute is still on the books. People say struck down, but the court never really revokes legislation. And my view with respect to Section 5 and preclearance is there's still a congressional obligation on the part of these states to submit their laws for preclearance. I understand the courts aren't going to be enforcing that regime, given the holding in Shelby County. But I'd like to see if somebody in the Biden administration wanted to be creative. They could have their attorney general send a memo to all those states who are subject to the coverage formula and tell them, look, you may think you're in the clear now because of what the Supreme Court said in Shelby County, but just remember, there's still a congressional statute here that requires you to submit your laws for preclearance. And just if, a future Supreme Court overrules Shelby County, just remember every single voting rights law you've passed since 2013 is going to be put back on ice because you never got the preclearance that our statute requires. We really shouldn't be thinking of the court as formally erasing the statute that was issued in Shelby County. Now, that said, given if Judge Barrett's confirmed, it's very unlikely Shelby County will ever be overruled unless there were 3 different vacancies for President Biden to fill. So that's really more of an academic question. In terms of what would the Roberts Court uphold with respect to voting rights, if I read the end of Shelby County, it looks to me as though the Chief Justice was trying to make it very difficult for any future coverage formula to work. And I would expect, unless there's a change in membership, the court to be skeptical of any kind of preclearance regime, regardless of what coverage formula is employed. And I think there's also going to be possible skepticism of voting rights laws that extend beyond, the core violations of the 15th Amendment. Right now, so much of voting rights law rests on disparate impact and the idea that facially neutral laws or policies or practices that have a disproportionate or discriminatory effect on racial minorities are being blocked by federal legislation. That's something that you may start seeing litigants push back against. I don't know if the Roberts Court will go in that direction, but that to me is going to be the more fertile ground for litigation in the voting rights field, rather than I think a congressional effort to restore a preclearance regime.
I mean, again, I kind of agree with a lot of what Jonathan said there, particularly on the views of the Roberts Court towards the Voting Rights Act. one of the things that I think is interesting is that if you look at some measures that have been proposed, like HR 1, is you may see much more effort by Congress to use other powers, the elections clause and the ability to regulate federal elections, and using that as a linchpin for enacting measures, and measures that are not limited to race. So measures dealing with voter registration, increasing access to the ballot, dealing with concerns about restrictive impacts from voter ID laws, laws that may affect issues having to do with gerrymandering. So I think that we may see perhaps a third iteration of a kind of thinking of the one person, one right, one vote as a first iteration, and then the Voting Rights Act and sort of the second level voting limitations as a second. I think we may be in one where we'll see potential assertions of national power to really overcome a lot of impediments to voting at the state and local level, and that will tee up questions about federal power, but I think they will be different questions than were addressed in Shelby County.
One person asks whether you think that Congress would be willing to rein in the president's emergency powers, given the kind of liberal use that President Trump has made of declaring emergencies.
I think that's an area that is obviously rife for reconsidering some of these emergencies, and that if you're going to have a delegation challenge, in some ways you would think it would be there. The problem is it's awfully hard to put in place ahead of time a statute that is limited enough in the authority that it delegates, but yet is available to deal with a real emergency. What I think you might see is an effort to change the termination of emergencies. So, many of these statutes were initially adopted, again, in the post-Watergate period, but also when it was before the era of Chadha and the demise of the legislative veto. And so one of the things that I think you might see, for example, on national emergencies is a switch to potentially requiring additional congressional approval for a state of emergency to continue, as opposed to Congress having to pass legislation with sufficient strength to overcome a presidential veto to end a state of emergency. So I think you might see some things like that. But again, I do think it's a real problem, because the very reasons why you want to grant authority to deal with an emergency may make members of Congress and certainly the president leery about measures that really try to dial it back too significantly.
Reminds me a little bit of the challenges Congress has had with enforcing the War Powers Resolution.
Yeah, exactly.
That's written in the way that you just described, where Congress is supposed to affirmatively take steps to authorize, or I guess authorize the continuation of hostilities after 60 days. And it's been a total failure in terms of controlling the president. Almost every president has violated it.
Sorry. Yeah, one other question. Do we have any evidence besides of what types of judges President Biden would want to appoint, other than he'd want to appoint judges who are likely to rule in his favor?
I mean, sure. I think that you look at people who were the leading contenders under the Obama administration, and many of them will be leading contenders under a Biden administration. Again, a lot will turn on composition of the Senate, and in terms of, you don't necessarily have the same filibuster rules, but still making sure you have people who there will be Democratic support for across the board. But I don't think they're hard to identify. There's a large pool of candidates because, as people have pointed out, Republicans have had way more appointees certainly to the Supreme Court than Democrats have had over the last few presidential administrations. So there are lots of folks up there you could consider.
Yeah, I think he has a deep bench of people he can choose. But I think also with Democratic presidents, I think Democratic administrations will be a little more sensitive to identity politics, or maybe that's not the right word to use, but diversity considerations than perhaps President Trump was. And we may see more of an emphasis on that in terms of the people he actually selects. If there's divided government, if there's a Republican-controlled Senate during any portion of the Biden administration, it will be interesting to see how they work that out. Will they make deals where they agree to confirm a very liberal Biden nominee in exchange for perhaps President Biden holding his nose and nominating a Federalist Society type of person? Or will the compromise be that they agree to two people who are more in the middle? Or will nothing happen at all? I'm skeptical. I mean, after Merrick Garland, I don't think we'll ever see a Supreme Court nominee confirmed during divided government. And I'm wondering whether we'll see Court of Appeals nominees get confirmed, just because it's not just with the election year issue where everyone wants to hold the seats open, but will there be a way for the parties to be able to come together and find mutually agreeable candidates? And it looks like it's getting harder and harder. They're able to make deals in the district courts. They're still doing that with the blue slip rule in place. So maybe there's not too much reason to be pessimistic. But we haven't yet seen, at least since the last 2 years of President Obama, a time of the White House being controlled by one party and the Senate being controlled by another. And you could see if Merrick Garland can't get confirmed in a divided government, I'm not sure anybody can, at least with respect to the Supreme Court.
Well, I see that our time has gone. It went by very quickly, and that was a wonderful discussion. I really appreciate the degree of common ground that we saw here this evening. And I just, if we were here in person, I would be leading the audience in a raucous round of applause for both of you. I can't do that, but thank you very much. And good night.
Thanks.
Oh, I should say, Chaz, would you announce our next program with Professor Grimmer? I forget the
Sorry, just looking at so our next event is on October 13th. That's a Tuesday. And it's going to be at 5 p.m. With Justin Grimmer, who's a empirical scholar at Stanford University, who's going to talk to us about what we know about voter turnout and the possibility of suppressing the vote. He studies these things empirically, so it should be a great event. And that's on October 13th at 5.
Thank you very much, and good night to everyone.